Thank you very much. Good afternoon, ladies and gentlemen, and greetings to my fellow panelists here. We have a very interesting theme to discuss this afternoon, and we have just about enough time to do justice to that, knowing that at 5:30 we have been warned that the buses will start leaving, and we certainly don't want to miss the bus, as it were. Well, this is an interesting theme because this is a theme which is dealing with new and emerging and nascent technologies, and we have known that one of the reasons for the increased importance of intellectual property in the world is because of advent of new technologies, which may be in the field of biotechnology or life sciences or nanotechnology or new materials or space technology or in the digital environment. And these new technologies, along with their interaction with global integration of economies and with the new disciplines and new challenges in economic, legal and diplomatic fields have brought about a new field of challenge so far as intellectual property is concerned, and simultaneously it has also increased the importance of IP. Now somehow the theme links new and emerging technologies to challenges with the TRIPS agreement, and I would leave my panelists to draw the link between these two. As far as I am aware, TRIPS agreement did not anticipate some of the new developments in technologies when it was finalized in 1994. It came into force in 1995. By and large, the digital revolution, except for the protection of semiconductors and some changes in the Washington Treaty, which was never adopted. And in Article 27, something about biotechnology inventions, the TRIPS agreement generally dealt with all fields of technology without any distinction. And I think that is the right course, in my point of view, to take in dealing with this subject also. And so the first set of issues which might arise in the context of new and emerging technologies are the legal and regulatory issues, whether they spring from TRIPS agreement or they spring from national laws, where ultimately protection will have to be sought, since IP is territorial in nature. And there, I think the general principles which are applicable to all technologies, and the TRIPS agreement, as I said, it does not make a distinction, because it says upfront that IP will be applied, the patenting can be applied to all fields of technology without any discrimination. And therefore, what is the patentable subject matter? What are the exceptions? Are there any exclusions and limitations? Now, in a general way, whenever a company, an institution, a research and development organization, or an individual inventor either starts inventing in a new field, or he has already something, this general area of what is patentable and what are the limits to the framework of patent will need to be examined by the inventor very carefully before he chooses to move forward. The other issues which inevitably in the field of new technologies will be the technological and technical issues. And there, how far is prior art relevant? Because if it is a new and emerging technology, maybe there is not much prior art, but you can scan, and you will have to scan, the whole field of patent literature, millions of patent documents which are there on your fingertips, to see whether what you are doing or what you have was somehow anticipated by either prior art or by any other patent which is either in force or which has already gone into public domain. And so this kind of patent mapping or patent scaping is something which is extremely important and relevant, not only for these technologies that we are talking about, but for all inventions. Also, this is important because one would like to be fairly careful that by moving ahead, either by using the technology oneself or thinking about other options, there is no chance to infringe anybody else's right. And that is another issue which will have to be at least thought of in the initial stages. Certainly, if the technology has emerged in a research and development organization, there is a proclivity, if I may say so, to publish even before you file. And this is something that we have often seen, and we have often advised our scientist friends that please, if you have something worthwhile protecting, please file a patent before you start publishing it. And that is something, again, which becomes relevant for our purposes. If the invention is still in the stage where it is being analyzed and scrutinized and you are moving forward, as has been pointed out in several sessions, you have a choice. You can do it in your own lab, or you can, as it is happening more and more, and especially in the case of emerging and new technologies, you may have to get into a collaborative or a inventorship situation, because maybe you are not able to have all the resources and all the know-how to move ahead on a totally new field, and so collaborative research becomes important. Or you may also take advantage of the avenues which are open to you in the field of commons, and many laboratories are doing that. In India, the Scientific and Council, the Council for Scientific and Industrial Research has a very big project on drug discovery, which is based on common platform. And so this is, again, another set of issues which will have to be considered by the inventors or by the institutions. And finally, if I may say that when it comes to the economic value or optimizing the economic value of technologies, what is the theme of the whole conference here, the very issues that we have discussed here, what shall I do as an inventor? Shall I go ahead myself? Or is there a buyer who can give me a good price for that technology? Shall I dispense with it? But first of all, should I patent it or should I keep it a trade secret? Another very important option that you have. Many technologies are kept secret till a time comes that they are made patented, but you must have the wherewithal to keep it secret or to keep that information confidential. Should I license it? Are there avenues for cross-licensing? Or should I go to an angel or a venture capital and see what are the prospects for my developing this technology, and then maybe when the value is a little bit more clear, I can go about in the market and see what is the best thing that I can do with this technology. So the whole issues of valuation of technologies, which have been talked about also, will become even more important in the case of new and emerging technologies, because you don't have a lot of examples where valuation has already been done, where you can have a historical comparison with what was available and what was the market value. And there is a new product in the market or a new technology, and you have to consider its value. So the valuation of IP in that sense becomes even more important. So friends, these are some of the issues which came to my mind. This is not exhaustive, and I'm sure some of them may not be even in the mind of our panelists. They may have their own perspective on coming from their own organizations and their own work as to what are the issues related to the TRIPS agreement or related to particular jurisdictions which are more important for us to consider. And I'll be quite happy that we have more and more issues which come up during these 4 presentations which deal with emerging and new technologies, because the subject is extremely important. The world is moving towards that. We have more and more, well, not so many disruptive technologies coming in, but certainly we have now 3Ds, and we have driverless cars, and all kinds of new things are on the horizon. And therefore, we should be very receptive to these ideas and see what are the issues that we need to be aware of, what are the ways we can protect and develop them, and ultimately, how do we optimize the value of those technologies. So with these few remarks, I would like to throw the subject open for discussion, and my first panelist to deal with this very important topic is Mr. James A. Larson. And I would take the cue from other technical sessions. I would request Mr. Larson to kindly take the podium and introduce himself. He is, of course, a partner a founding partner of Hamre, Schumann, Mueller, and Larson from Minneapolis, one of the very important centers of law firms in the USA. Mr. Larson, you have the floor, and we would like to have your perspective on this topic. Thank you.